other ones are, in fact, if one of them is indisposed, the other two are in the panels, and they're in all these panels that they have set, and they have started working seriously. Is there any other question? Is there any observation? Eh? They are online. All right, so I can go on. Patience, please call up the matter. Okay. Appearances, please. Okay. Appearances, please. Are you hearing me? No, he said if he unmutes me to start echoing. Okay, then come. Where is Yinka? Oh. Unmute me here. I put off this so that it won't echo. Hmm? Have you logged in?
Good afternoon, my lord. My lord, we are not hearing. The court is mute. The court is mute. We can't hear the court. It is the court.
Can you hear me now?
Yes, my lord. We can hear you.
Okay. So let me take your appearances, please. And
Okay.
your voice is so faint. I can hardly hear you.
May it please me, Lord.
Please.
May it please me, Lord.
Yes.
Triumph Ate.
Yes.
With me, Kelvin O. Tiku.
Yes.
For the claimants.
Very well. Yes. Who is for the defendants? Okay. Daniel Kip, you're not here? No appearance. No legal appearance for defendants. Okay, Triumph.
Yes, my lord.
Are you ready with your final written address?
Yes, my lord.
Yes. Have
Yes,
you received any final written address from the defendants?
None, my lord. The defendants have not filed.
Till date?
Yes, my lord.
You recall what played out on the last adjourned date? They said the defense
Yes,
counsel,
my lord.
The defense counsel has passed on, but somebody replaced him in the chambers. Would you know anything about that?
My lord, that was just an information which the court was minded to act on. But my lord, that law firm is a law firm made up of close to 20 lawyers, to my knowledge.
Yes.
And the counsel that was in charge for the case is the head of the chambers, Leonard Asolata Ochinke.
Yes.
Who is very healthy and happens to be the chairman of the Calabar branch of the MBA.
I see.
Yes, my lord. So that excuse that was given on the last day, which the court indulged them, was enough for them to have filed The matter came up last on the 16th day of March.
Yes.
And today is 2nd May, over a month, and they
Yes.
have not filed. It shows that either they are trying to delay the case, which they have been doing by records of court. The court will see the several lapses which they have been creating or foisting on themselves. My Lord, today is for adoption. Even the cost that was ordered by the court, which we wrote to them to pay, up to date, that cost have not been paid. My Lord, in the circumstance, we will be applying to the court to grant us leave to adopt our final written addresses. The defendants haven't been given ample opportunity to file theirs, and they have so failed. They will not be heard to say that their right to fair hearing has been abridged, because the courts cannot wait for them in perpetuity. Yes, my Lord.
I see. Well, you know why the court indulged them, as you said, on the last adjourned date. If they tell the court that the head of the chambers passed on and somebody is trying to take his place, the court couldn't have done any other thing but to grant them some time. But the time given by the court is quite enough for them to do.
Yes, ma'am.
Yes. So as it is, and there is no letter. Is there any letter from the defendants in court? There is no letter before me. So it only means that they are not ready to continue with this case. But the court cannot wait indefinitely for their pleasure coming to court. So
Yes,
I will direct that you adopt your final written address.
As the court pleases.
Yes. Direct the claimant. And so to adopt his final written address. Yes, I'll put you on record. So go on.
Thank you very much, my Lord.
Yes.
My Lord, before adopting the final written address of the court of the claimants, I want to draw the attention of the court to the fact that this matter is a consolidated matter.
Yes, I recall, yes.
Yes, my Lord. So that the two addresses for NICN CA 30-2017 will apply mutandis mutandi to NICN CA 31, which is a sister case. The facts are the same.
Now, let me have the numbers again. The first one is
NICN
yes.
CA
Yes.
30 2017.
Yes.
And
yes.
the second one is NICN
31.
Yes, my Lord.
Yes. So,
My Lord,
this address is going to be going.
Yes, my Lord, we did file separate addresses, but the same contents.
Very well. That's the proper thing to do. Yes.
Yes, my Lord.
Yes.
With the leave of court, we will adopt the final address in respect of 30.
Okay. Yes.
The claimant filed his final written address on the 28th day of November, 2022.
Yes.
Notwithstanding that, yes, my Lord, the claimant raised or formulated a loan issue for determination
Yes.
which have been canvassed succinctly
Yes.
as shown on the said written address.
Yes.
We hereby adopt as our final written address in this case.
Yes.
And urge the court to grant all the relief sought as shown on the face of the originating process, the complaints.
Yes.
My Lord, the claimant will not want to balk the time of the court because the defendants having not filed as required by rules of court, issues have not been joined.
Okay.
The issues are deemed to have been admitted. We urge the court accordingly to grant all the relief sought by the claimant. We so pray, my Lord.
Very well.
My Lord, in suit 31,
Is this authority in your final written address? Is it caught in your final written address?
pardon me, Lord.
You said, okay, you're talking about the second suit, that is 31/2017. Okay.
Yes, my Lord.
Okay.
The consolidated suit, my Lord.
Yes, yes.
That the claimant filed his final written address also on the 28th day of November.
Yes.
A loan issue has been formulated
Yes.
and canvassed succinctly thereon.
Yes.
The claimant prays the court to grant all the reliefs as shown on the face of the complaints.
Yes.
Beloved, before we humbly submit, we adopt the said written address, the final written address,
Yes.
to urge the court to grant the reliefs.
Yes.
My Lord, in the main, the claimant's case, in summary,
Yes.
is in challenge of the manner in which
Are you at breath now?
yes, my Lord. In which,
Yes, but please abridge the adumbration.
as the court pleases.
Yes, because I'm sure the address has captured all whatever you have to say.
As the court pleases. My Lord, save that I wanted to furnish the court with a recent authority.
Okay, that is acceptable.
We deal with master-servant relationship.
Okay.
My Lord, the authority is the case of Adedeji versus Central Bank of Nigeria.
Adedeji
Versus Central Bank of Nigeria.
Yes.
citation is 2023.
That's fresh from the oven.
Yes, my Lord. Yes, my
Mhm.
Lord. That's why I needed to bring it to the court. And it's a
Yes.
Supreme Court decision, my Lord.
Okay. Well, how about the citation?
Yes, that's the citation. 2023, 5 Nigerian Weekly Law Report,
Yes.
part 1878.
Yes.
Page 531.
Yes.
Yes, my Lord, the Supreme Court did classify nature of contract of employment into three.
Okay.
There is the common master-servant relationship.
Mhm.
There is the relationship where the servant holds a position at the pleasure of the master.
Yes.
And the third one is that which is governed by statutes, with statutory flavor.
Yes.
My Lord, looking at the case of the claimant, it falls under the first category.
Okay.
And in such a case, the general law is that the court will not force a willing servant on an unwilling employer or master.
Yes.
However, as such relationship is governed by the prevailing laws and the contract documents.
Yes.
In present case, the contract document, which was an exhibit before the court, is the negotiated conditions of service for workers of BSF Plantations Limited and AOP Industry Limited. It's an exhibit before the court. And
Okay.
the Supreme Court went on to say,
Yes.
in such a case, termination of such relationship must be in line with the said documents.
Yes.
My Lord, the first to third defendants engage, the first and second defendants engage the third defendant to arrest the claimants.
Yes.
Tortured him, and summarily disengaged him, collected the bulldozer key, the bulldozer the claimant was driving, and sent the defendant away, the claimant away, with no pay, no entitlement, in outright breach of the said documents.
Yes.
My Lord, such practice is inimical to civility, decency in the labor ecosystem, and global best practice.
Yes.
The claimant is not praying for reinstatement, as that is uncalled for and untenable, but the claimant is praying for his entitlement from when he was disengaged, and then damages for the breach of the contracts. Lord, we pray the court to grant all the reliefs as sought by the claimants. We are most grateful, my Lord.
Yes. Yes. That's all right. And this is a very old case, 2017 case.
Yes,
We were
my
in
Lord.
2023.
Quite unfortunate, my Lord.
Yes. No, Patience, please bring our diary. I don't know when to give them for judgments. And if we finish, this is the last one.
They are doing it at one case, so they know fine. When the court have the court have been every process is fine. Matter was for you in the
What date?
Lagos.
So, Council, how do you stand on the 5th day of July?
5th day of July. My Lord is convenient.
Council, can you still hear me?
Yes, it's convenient, my Lord.
Can you hear me?
Yes, my Lord. Wednesday, 5th July is convenient.
How do you stand on the Okay, it's convenient, huh?
Yes, my Lord.
5th day of July,
Yes, my Lord.
2023. So this matter is therefore is hereby adjourned to the 5th day of July, 2023 for judgment.
As the court pleases. We are
Okay.
most grateful, my Lord.
This matter don't finish, Oh, go break. Okay.